Welcome, I'm David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. I want to talk about the difference between two ways of resolving a case. One is arbitration, the other is trial. Now, arbitration tends to be a little less formal. In other words, arbitration is handled or conducted in an office as opposed to in the courtroom. And that arbitration is conducted in front of a generally a retired judge or an attorney who specifically handles arbitration matters. In a courtroom, you're in front of a judge and or a jury in the courthouse. That's one of the differences. Another difference between the two is the rules of evidence. You might find that in an arbitration, the rules of evidence are less formal. In other words, documents and witnesses can be introduced or present evidence and testimony without going through a lot of the formalities that are required in trial. The advantage to arbitration over trial in that situation is that it speeds up the process a little bit more because you don't have to go through a number of witnesses to establish certain basis for documents and things of that nature. One of the other differences between the two is the right to appeal or change the ruling if you don't like the ruling. In arbitration, you generally waive that right early on. Now, there are some limited circumstances where an appeal may be allowed, but in trial, you generally don't waive that right for an appeal, and so you have the right to bring it up to another court or even to a third court to have that court decide whether the initial ruling was appropriate. So those are just a few of the differences between arbitration and trial. And it just depends on your circumstances whether your case will be resolved at arbitration or trial. Speak to your attorney about that and figure out which one's best for you.